the whole issue about the waiver of Miranda rights was never really the focus of the hearing.
That's correct. That it's a separate. They're two separate inquiries, but I think that the inquiries again are very much intertwined. If someone has been, somehow coerced or compelled into giving a statement, then clearly that would not be voluntary. But also, depending on the nature of the compulsion, it also could be the same, that it's not a knowing waiver. And so, I think these issues are intertwined as to whether or not the waiver was voluntary. I mean, to answer your question more directly, I think the assertion was that he was essentially coerced because of these same factors into giving the statement. And so, again, I think that is hand in glove with the same issue, though they are a separate inquiry. That is correct. I feel that, finding that there's some sort of coercion or compulsion also makes the waiver not knowing necessarily. So I think that the focus of the trial court suppression hearing by the defense was more on the nature that he was in a police car, and again, some of the issues that I just mentioned, some of the facts, that there was not an express, the detective said that she did not expressly tell him he had the right to end the interview, that he had the right to leave anytime that he wanted, and things of that nature, even though some of those are contained in the standard Miranda waiver.
Didn't they actually kind of go off the standard Miranda and just kind of give a thumbnail explanation of which each of those rights were?
Excuse me, Your Honor. They expounded, and it's been a long time since I have listened to the interview itself, but based on what the testimony, my recollection of the testimony, they did not expound a great deal, in my opinion.
What they did was, I think, if I remember correctly, is they said, like, you have a right to remain silent. In other words, you don't have to tell us anything if you don't want to. If you have a right to an attorney, and that means that if you want an attorney present, we'll stop the proceeding and you can get one, or we can find you one, and things like that.
Well, I mean, yes, again, they did expound some on that, is my recollection, but also, the sort of circling back to the same issue, I mean, whether or not I certainly would have understood what that meant, even if I wasn't an attorney who practices criminal law, but I'm not 16 years old with a 8th grade education. So again, I mean, I think the knowingness and the voluntariness, I mean, he's somebody that could be easily compelled or coerced, convinced, whatever verb you'd like to use, to so waive his rights based on that. So I think the inquiry is largely the same on a factual basis, but yes, they are separate inquiries. That's correct. Be that as it may, I believe that the trial court was in error when they denied Mr. Lakka-Lako's suppression motion. Unless there are further questions on that, I would address a couple of other issues. First, as to his sentencing, he was 16 years old the day that he got arrested, and as I've noted in my brief, his sentence, if he even lives to complete it, will make him approximately 60 years old when he's released. The offenses that he's convicted of are some of the worst that he could have been convicted of. Punishment is warranted, for sure, and serious punishment. But having a juvenile essentially serve a life sentence, I don't feel is appropriate, and I don't feel that the trial court, though she did more or less recite that she considered the sentencing scheme that the General Assembly has laid out, I feel like this sentence, making each of the sentences the maximum possible sentence within the range of punishment, and then making 2 of his 25-year sentences consecutive to one another with no release eligibility, is close to the maximum sentence he could have gotten. So to say that this is the least restrictive measure, certainly general and specific deterrence as to Mr. Lakka-Lako was warranted, but it doesn't take into account his ability still as, I believe, a 20 or 21-year-old at this time to rehabilitate himself at some point in the future. It doesn't take into account that less restrictive measures are available to the court that still meet the other principles of sentencing. I understand I have an extremely high burden and hill to climb on sentencing issues, and I understand that this is not a compelling defendant based on his conduct, but a 50-year sentence at 100% for a 16-year-old in a non-homicide is extreme, And so I don't feel that the trial court has, despite saying that they had, I don't feel the trial court really engaged in the sentencing process in the way that was that is mandated. And I feel that this sentence does not align with the general sentencing principles. He has
Mr. Russ, I agree with you on you have a heavy burden on this sentencing issue. I mean, the bottom line, even if we agree with you, we're reviewing what this trial judge did, and if she said, this is what I'm considering these statutory factors, and I'm considering this, and I'm considering that, how could we say, in an opinion, well, she said that, but we're not sure she meant it?
Well,
I see
the dilemma, Your Honor. I was actually drafting another brief with a similar issue this week. It is a difficult position to put this court in. However, I don't think that simply reciting or the incantation that says I've considered the sentencing principles laid out by the General Assembly and I arrive at X somehow immunizes it from some sort of meaningful review. I do recognize that my burden is very high here to convince you to do that, but I think that simply saying I've considered the sentencing principles and I feel like this sentence is appropriate is not sufficient simply in its own right. And to be fair, I think it was more in-depth than simply saying that one line. But again, to have arrived at a sentence of this magnitude, even under these facts, I feel simply saying I've considered all of the sentencing guidelines and principles, including that rehabilitation is an important factor for every defendant, and that his age being what it is, he has the ability to rehabilitate himself if he so chooses, and that this is not the least restrictive measure. I think if something like that, again, would show more of an engagement rather than just reading off that the sentencing principles had been considered. So I appreciate the court's position given the case law and that my burden is high, but on the other hand, I think simply saying those however many lines don't immunize the trial court from any kind of review. The last issue, which I'll just address briefly, the state is correct in their brief, and I have my wires crossed in my brief. A serious bodily injury is not an element of aggravated rape. That's correct, but it is an element of especially aggravated burglary, and I think I just went down a rabbit hole. But be that as it may, I still think the issue is important for the convictions for especially aggravated robbery and especially aggravated burglary. There are cases that are similar to this along these lines, but I think that the main thing is, was her decision to jump out the window the natural consequence of Mr. Lakka-Lako's act? And I don't think that could reasonably be expected to be the natural consequence. Could we take a step back and say, had he never gone in her apartment, none of this would have happened to her? Absolutely, but that's kind of something you can do for every offense. But her decision to leap from a second or third store balcony is not necessary. He wasn't chasing her out there and pushed her off or anything of that nature. So I think.
Let me just stop you for a second. I mean, when you start to look at natural consequences of an act, I mean, the case law in Tennessee is pretty broad in its view of what is a natural consequence. I mean, if she had died of a heart attack during this event, that would probably be considered a natural consequence. The fact that someone has some, you take your victim as you find them, and if they have a heart condition and you cause your act results in them having a heart attack and dying, I mean, I can see it being a natural consequence. And the fact that she was so desperate to escape that she jumped out a window, you don't think that is so unforeseeable it would not be a natural consequence?
I think it's very unforeseeable. Personally, I mean, I saw one or two cases in the last 30 or 40 years that were cited or that I had researched that had a similar fact pattern. So I think it's fairly unusual. Yes, I don't think that is a natural consequence that should have been expected by Mr. Lakka-Lako. whether or not you do take your defendant as you find them, I suppose if it had been someone who had a heart condition and caused it, the scenario that you've proposed, that might have been different, but I don't think someone leaping from a balcony is a natural consequence that the defendant would expect based on his or her conduct. So I'm into my rebuttal time, but if there's any other questions, I'll maybe address them in the second time around.
Fine. Thank you, counsel. Good morning.
Good morning, Your Honors. May it please the court. Philip Hammersley on behalf of the state. Defendant Dantis Lakka-Lako entered the apartment of a vulnerable and pregnant Miss Hatu. He armed himself with a knife, and then he brutally raped her. Fearing for her life, she managed to escape by jumping out her third-story apartment window. She shattered her pelvis and sustained other serious injuries during the escape. On this direct appeal, the defendant does not dispute those key facts. He does not say that the police got the wrong person, he does not deny raping Miss Hatu, and he does not deny stealing the Hatu's car or other belongings. Instead, he raises a Miranda issue, a sentencing issue, and a sufficiency of the evidence issue. Because none of these arguments have merit, the convictions and the sentence should be affirmed. I'd like to start with the admissibility of the defendant's confession. Because the defendant did not present the Miranda issue below, the court reviews for plain error. And here, there is no error, plain or otherwise, because the confession is admissible. The trial court did not violate the defendant's Miranda rights by admitting the confession for two reasons. First, because the defendant was not in custody in the first place, he was not entitled to Miranda warnings at all. And second, even if the defendant was entitled to Miranda warnings, he validly waived his Miranda rights. So I'd like to start with custody, which the other side did not address in his argument, but I think it's an important starting point. The key question for custody is whether a reasonable person in the defendant's position would have thought that his freedom was limited to the degree of formal arrest. Now, the state, of course, has briefed this issue and gone through each of the factors, and I don't want to rehash all those. I just do want to emphasize two key facts. First, the defendant voluntarily accompanied the officers to the unmarked squad car without restraints. Nobody forced him to go there. That was a choice that he made. Second, the officers, before the interrogation, told the defendant that he was not in custody. Now, given those facts, combined with the defendant's previous experiences with the police and being read his rights, a reasonable person in his shoes would not have felt restrained to the degree of formal arrest. As I mentioned, the defendant has said nothing about this argument, and I would submit that this would be an easy way for the court to address the admissibility of the confession without having to get into the waiver issue. But if you do choose to address waiver, a Miranda waiver is valid if it is knowingly and voluntarily given. The defendant's waiver here meets that standard. First of all, the defendant signed a form memorializing that he understood and waived his Miranda rights. That form provides strong proof of the validity of his waiver, as the Tennessee Supreme Court has said, and as the United States Supreme Court has said. During the questioning of the appellant, one of your honors noted that it was not just the form. The officers explained in easy-to-understand terms what each of the rights, each of the Miranda rights means. So this is from Trial Record 1 at page 5. They're reading and explaining the form. So it says you have the right to remain silent. Anything you say can be used against you in court. That means you don't have to talk to us. On page 6. You have the right to talk to a lawyer for any advice before we ask you any questions and have him or her with you during any questioning. That means if you want a lawyer, you let us know. We'll either help you get one or you can get one. So the defendant makes much of the fact that this was a young man, and that's certainly true, and that's something that the trial court took into consideration, and your honors should take into consideration. But the officers here went to great lengths to ensure that the defendant understood the rights and understood the consequence of waiving those rights. Of course, there's two different things to consider with respect to the validity of the waiver, whether it was knowing and whether it was voluntary. Speaking first to the issue of knowing, the defendant's waiver was knowing because he understood his Miranda rights and the consequences of those rights. Of course, the Callahan factors do apply, and under those factors, the defendant could read and write English. He orally acknowledged that he understood his rights. He signed the waiver form acknowledging that he had been read his rights, he understood his rights, and he wanted to talk. And he had familiarity with the legal system. The defendant said during argument that it was unclear the extent to which the defendant had experience with law enforcement officers. This is from page 22 of volume 1. This is the trial court's order denying the motion to suppress, where the court found that the defendant, quote, had previous experience with law enforcement and admitted he had previously been advised of his rights during an earlier encounter with the police and had experience with an attorney in the past, end quote. That's what the trial court found. So this is someone who is young, but this is someone who has experience with the juvenile system, has familiarity with the Miranda rights, and has been through this process before. The defendant's argument really boils down to, because this person was a juvenile, his waiver should be presumed invalid. But there is, of course, no presumption of invalidity for the waiver of juveniles, and the state has cited various cases in the brief, one of which I'd like to draw your attention to, which is State versus Swader. This is cited on page 30 of the state's brief, which explains that a 16-year-old defendant validly waived his Miranda rights because he signed the waiver form, he understood English, and he had the capacity to understand his rights based on his familiarity with the legal system. Moving to the next requirement, which is voluntariness. A waiver must be voluntary in the sense that it was a product of free and deliberate choice rather than intimidation, coercion, or deception. That is certainly the case here. There was, of course, there was no parental figure during the interrogation, but that is not dispositive. There were no coercive tactics used or unique susceptibilities among the defendant, except for his young age. He was not sleep deprived, on drugs, or in need of food or medical attention. Now, the other side has said that, well, I suppose acknowledged that the voluntariness inquiry differs. It is technically a different standard based on whether you're considering the voluntariness of a statement under the Due Process Clause versus whether a waiver itself was voluntarily given. That is correct. Those are different standards. The Tennessee Supreme Court has said that many times, most recently in McKinney. So the fact that the defendant raised a due process voluntariness argument below is not sufficient to preserve voluntariness with respect to his Miranda waiver on appeal. The appellant has said nothing about plain error, so unless your honors have questions about plain error or harmless error, I think I'll rest on the briefs with respect to those issues and instead move to the sentencing questions. The trial court did not abuse its discretion when sentencing the defendant. The defendant raises two issues here. First, the legality of his maximum in-range sentence and the legality of the consecutive sentencing decision. First, the court did not err by giving the defendant the maximum in-range sentence for his especially aggravated robbery and aggravated rape convictions. The defendant attacks his sentence by arguing that the trial court did not adequately, essentially, explain its decision or consider the factors. That is wrong. The Tennessee Supreme Court said in Buys that the sentencing decision need not be particularly lengthy or detailed. All the court must do is, quote, set forth enough to satisfy the appellate court that it has considered the parties' arguments and has a reasoned basis for exercising its own legal decision-making authority. And that's precisely what happened here. The court said that it considered the parties' arguments. It held an individualized hearing to consider the parties' arguments, at which point there was mitigating testimony offered by the defendant. The state and the defendant argued about the applicability of certain enhancement factors and consecutive sentencing factors. The court took those issues under advisement, took a break, and then reconvened the hearing and imposed the sentence. During that imposition, it walked through the relevant statutory factors and explained its decision, and it justified its sentence with respect to the requisite statutory criteria. That is sufficient, certainly, to obtain the presumption of reasonableness, and it is also sufficient in and of itself to satisfy the statutory requirements. But even if Your Honors believe that the trial court did not adequately explain its decision, that alone does not overcome the presumption of reasonableness which applies here under Buys. The defendant offers no arguments about why the enhancement factors that the court relied upon apply, and that, again, is enough reason alone, I would submit, to affirm the sentences because the defendant bears the burden on appeal. Essentially what the defendant would have the court do is second guess what the court did and whether it in fact properly considered the various sentencing factors and criteria. That would turn the presumption of reasonableness on its head. It would be inconsistent with Buys. The court also did not err by its consecutive sentencing decision. The Tennessee Supreme Court has held in Pollard that finding even one consecutive sentencing factor is enough to impose a consecutive sentence. The trial court here found 3, none of which, again, the defendant attacks on appeal. He instead argues that the court failed to explain why the selected sentence was the least severe measure necessary. Now, I would note that as the cases cited in the state's brief confirm, there's no requirement that the trial court explicitly address this prong. Beckham, Hurt, Midget, all 3 of those cases from this court in the last 6 or 7 years affirm that the trial court can satisfy its obligation without expressly explaining why the sentence it imposed is the least severe measure necessary. Unless there are any questions about the sentencing, I'd like to move to the final issue, the sufficiency of the evidence regarding causation. The defendant challenges whether the jury had sufficient evidence to conclude that he caused the victim's bodily injuries. I just want to set the stage a bit here. There are 6 convictions total, only 2 of which are being challenged under this issue. Count 1 for especially aggravated robbery, and count 3, aggravated rape requiring bodily injury. My friend on the other side referenced especially aggravated burglary during his argument. I want to note, and you can read more about this in footnote 1, page 11 of the state's brief, the especially aggravated burglary conviction was vacated and replaced with aggravated burglary. So there's no especially aggravated burglary here at issue with respect to the sufficiency of the evidence. But going to aggravated rape, to convict the defendant on count 3, the jury had to find that the defendant caused bodily injury to the alleged victim. Bodily injury is defined to include cuts, abrasions, and bruises, and in the state's election of offenses below, they relied on the defendant striking the victim in the face as the cause of the bodily injury. They do not assert any injuries in connection with Ms. Hatu jumping out the window. There's testimony, of course, from the victim that the defendant punched her in the face, bruised her in the face, and there are corroborating photos showing those bruises. That's enough to find bodily injury to support the aggravated rape conviction. Moving to the especially aggravated robbery conviction, there's of course no question that the victim suffered serious bodily injury when she jumped from her 3rd-story window. Instead, the defendant argues that he did not cause those injuries. Of course, as Your Honors said during your colloquy with the other side, the causation standard is whether the injury is a natural and probable consequence of the defendant's conduct. Of course, jumping to escape is a natural and probable consequence here, given the circumstances that the defendant put Ms. Hatu in. First, attempting to escape given this set of facts, that is, of course, entirely natural and probable. The defendant must have known that if he had raped a person, threatened her life, came into her bedroom armed with a deadly weapon, that person would try and escape. Second, Ms. Hatu made the reasonable choice to jump out her window because she wanted to avoid confrontation with the defendant. After she fought back and struck the defendant on the head with a bottle, he left the room, presumably to clean himself up, and she did not know where he was. She is smaller than him. She's 5 months pregnant. There's a bit of a language barrier. She's new to this apartment. She made the choice that rather than going out of the bedroom and risking perhaps the defendant got another knife, perhaps he had a gun, perhaps he had help, she made the reasonable decision and the unfortunate decision to jump out the window, sustaining her admittedly serious injuries. I want to make clear that the defendant does not have to foresee the precise injury in order for causation to exist. I direct your honors to Spivey versus St. Thomas Hospital, 211 SW 2D 450. It's enough that the defendant foresee that there would be harm, that there would be injury suffered as a result of his actions, and that's certainly the case here.
General, may I ask, should there be a distinction drawn here between what is foreseeable as a result of the rape offense versus what is foreseeable as a result of the robbery offense?
I don't think that your honors need to draw that distinction here. Certainly with respect to the robbery, that started happening before the sexual assault occurred, and it continued until after the sexual assault had concluded. Of course, we know that the defendant, after Ms. Hatu jumped out the window, took the keys to the family car, got in the car, and drove off with it. So I don't think that your honors need to parse through the separate convictions for purposes of considering the bodily injury. And I would also say that if you disagree with me, you'd only have to do that if you don't think that the bodily injury from the bruise satisfied the statutory requirement, because there's no serious bodily injury required for the aggravated rape conviction, and there's only one aggravated rape conviction being challenged here.
I'm thinking more in terms of the robbery, though. I mean, it seems like it would be one thing to say that her reaction was a natural consequence of the rape.
Certainly.
But to say that it was a natural consequence of the robbery, if you separate the two analytically, which I don't know that you can in this type of situation, that was really more my question. Is it the same for the robbery?
I don't think so. You have the defendant coming in with a knife. He says he wants things. He's going to rob Ms. Hatu. So even if you set aside the fact that he sexually assaulted her, I think it is foreseeable that when someone comes into your home armed with a knife saying, I'm going to rob you, you are going to, if you're a pregnant woman alone without your husband, you're going to try and escape. And that's something that the defendant would have reasonably foreseen. And the fact that that escape took an unconventional, manifested itself in an unconventional way, that doesn't save the defendant. So I agree, Your Honor. I'm not so sure that you can bifurcate those two, but even if you could, I think it is indeed a natural and probable consequence just of the the especially aggravated robbery. And of course, Your Honors have the Locke case cited in the state's brief. I want to make sure that Your Honors understand Locke is not some outlier. This issue has come up in other jurisdictions, including in Illinois and in Massachusetts, where courts have reached the same result, right? Where victims jump out the window in response to intruders, and courts find that those injuries are in fact caused by the defendants. First case is People versus Ramey, 606 NE 2D 39. That's from the Illinois Court of Appeals. And then the second one is Com versus Thomas, 50 NE 3D 453. That's from the Massachusetts Court of Appeals. Unless Your Honors have any further questions, the state would respectfully request that Your Honors affirm the convictions and the sentences. Thank you.
All right, thank you, General. Got your rebuttal time?
Yes, Your Honor. I think I ran into it a little bit, but I'll be brief. As to the last point that you were making, Judge Hickson, I do think there is a distinction. Again, it has to be the natural and probable consequence, particularly of being robbed with a knife. I don't think it's natural to think someone would leap from a building to avoid that, particularly after it had already been completed. He had already taken the property by the time this happened. So I do think there's a distinction there, and I do think it's an important one. To one of the arguments the state was making related to the sentencing, we have not argued, and I don't think we can argue, that the trial court couldn't have found that these sentences could be consecutive. We're arguing that she shouldn't have done so. So, I mean, that isn't the basis of the argument that we're making. Whether, again, we would feel that the arguments we raised as to the suppression issue were properly raised in the trial court, but if we're under a plain error analysis, I did not address that in my brief, but briefly to go over it, I further and further don't believe there's any meaningful distinction between plenary review and plain error review. If the court feels there's no breach of law here, then you wouldn't grant relief under a plenary review any more so than under plain error. If there was plain error here, there was no tactical reason for Mr. Lakka-Lako not to pursue the argument that there was a lack of voluntariness and a lack of a knowing waiver. The record is clear as to what happened, both the pleadings and the testimony from the parties involved. And clearly a statement wherein he admits some of the conduct here is adverse to him. So it boils down to, do you think this is necessary to do justice? Which to me is basically the rough equivalent of whether there's prejudice or not. So if you've determined there is an error here and it was under plenary review, you still have to find it was prejudicial to him. If you've determined that there was plain error here and there was a breach of law, it would have to be necessary to do justice in order to grant relief, which I find to be basically the same thing. Maybe you don't, but I would make that argument that under either standard, if there has been error here, it certainly has been prejudicial to him, and so I think relief should be granted. Unless there are any further questions. Yes.
Sentencing. Aggravated rape with bodily injury doesn't require serious bodily injury. It just requires some bodily injury. Bruise, cut, is sufficient, isn't it?
Under the sentencing or sufficiency issue?
On the sufficiency of the issue.
Oh, I'm sorry. Yeah, yes. I was mistaken in my brief. Yes, that is correct. That aggravated rape only requires a bodily injury. The other alternate count, I believe, was because a weapon was used.
Correct.
So, but yes, that is correct. The state's correct in stating the law there.
Okay.
Thank you.
All right, thank you. Call the next case, please.
State of Tennessee versus Jennifer Michelle Childs.